Conversation continues with Senior Counsel Abdulkadir Mohammed, who was the first chair of the committee oversighting the implementation of the Constitution after its promulgation in 2010, and Dr. Ekuru Aukot, who's also a constitutional lawyer. He was the CEO of the committee of experts that wrote Kenya's Constitution, and has been involved in drafting several other constitutions across the continent, where Liberia, South Sudan, you are in the Maghreb after the Arab Spring, and so on and so forth. Now, we are looking at that matter, and Abdulkadir has brought in a serious issue here, that the spirit of the Constitution here was that the impeachment process is a political process. It's a process to oversight the executive. It's a political way of oversighting the political heads of the executive, right? If they misbehave, then the people's representative through the National Assembly and the Senate shall take action, right? And there are several safeguards. The high threshold, 1/3 of members of parliament have got to okay a motion to be brought into the House. 2/3 of members of parliament have got to say, yes, there's ground to impeach. 2/3 of the members of the Senate have members of the, not even delegations, this one. It is all members of the Senate. 2/3 of them have got to say, yes, there's any of these grounds is strong enough to meet the threshold, constitutionally set threshold for impeachment. It's a political process. The question comes, though, when you have a rogue parliament, like you both gentlemen have said, you have a parliament that does not know head or tail, cannot tell its feet from its toes, right? So a parliament then that doesn't do the job as expected of them to do. Don't you think then the person being accused deserves an opportunity to have someone else to check?
Absolutely. You
and
see,
we have the judiciary for that.
Yeah. So, Latif, politics does not take away the legality or the constitutionality aspect of it. And that's why, in the constitution making process or in the constitution itself, articles, there are many articles, the Bill of Rights, for example, in Article 50 talked about fairness. If you are going to try somebody, it's not the politics, because we know our politics is completely messed up. It is tribal, it's regional, it's balkanization. The very, very charges that Rigathi Gachagua was charged of, that of ethnic mobilization or whatever. In fact, if you are to remove the name Gachagua from that charge sheet and replace it, say, with Ruto, the list will probably be longer. Or replace it with any of the politicians, the list would be longer, especially those from rural constituencies. Because for them, the mobilization is around tribe. And there's nothing absolutely wrong with identifying with members of your community or your ethnic group. I think the problem is when you make it negative. Now, if you're going to try somebody because of that, and if you look at the character and nature of our politics in Kenya, it's very tribal. There's nothing criminal about that per se, okay? Only when you're mobilizing the tribe against another group or tribe, then it becomes criminal. But just to identify that I come from this region, like for me, you can't take away the fact that I'm a Turkana. But I'm proudly Kenyan, but of Turkana extraction. Just like you cannot take away the fact that Abdulkadir is Somali or, Ziti here is Luo.
On a light side, there was a rumor when we had hired, when the parliament said Dr. should be the CEO. Yeah. There was a rumor, and it's never been confirmed, that former President Moi was told this and said, "What? Katiba to be written by a Turkana?"
No, it was not a rumor. No, he said it actually. He said it. What Katiba can be written by a Turkana? That's no, seriously. He said it. He said it. I mean, let's not talk about the dead. But actually, he did say it. That's exactly how.
We had a good laugh about it.
Yes. In this country, people do not look at, for example, your competencies.
So what you're calling, maybe our rotten politics, is the reality of our politics.
Yeah. It is the reality of our politics. And that's why, for me, you cannot lock away the opportunity of a person who has been lynched politically, as in the case of Gachagua. And I'm not holding his brief. The truth for the matter is Gachagua was lynched politically. We don't even know what went wrong between him and in fact, if you are really to compare this presidency and the previous presidency, it makes Uhuru an angel. Because if there is one person, I think, who even disrespected openly is president. It was actually now President William Ruto when he was deputy to Uhuru Kenyatta. But Uhuru Kenyatta, in his magnanimity, probably out of respect for the presidency, did not want to move an impeachment.
Or maybe he didn't have the numbers.
Well, he had the numbers. He had the numbers. He could have marshaled the same way Ruto has marshaled. But I think if you are really to compare, the two presidencies, I think it really has exposed the underbelly of Ruto as a very bad person.
So then, in your argument, Dr. Okot, if then you have the judiciary and you say that this also can end up in the judiciary, in what stage, at what stage, and in what shape and form? Because you see, like what Abdulkadir is saying, if we were to look at it, from that angle, then it would be about the process. The process being followed. Was the process duly followed? What do you think? What do you say? Where is the judiciary?
At the end of the day, Latif, you have put me on trial. You have charged me. You have trumped up charges. Some of them, all of them almost unsubstantiated. Even from the key witness himself, as you saw. He looked very silly. He was like, you wondered, where did he stumble upon his elementary law, honestly, even as a lawyer? And so I think the question really is, if you must put somebody on trial, follow the rigors of the law. Follow the Evidence Act. Follow treat him.
Is that what you guys expected Parliament to be doing?
Well,
it's like you expected Parliament to understand the law. You cannot guarantee that Parliament will then have lawyers as members.
You can't say
who will think about it. If you wanted that, Dr. Ekuru Okot, why take impeachment through Parliament? Why not just say establish a commission, a special tribunal,
actually,
judicial, that then will look at it that way?
Let me tell you why Rigathi Gachagua was politically lynched. If you look at the process of impeachment, ideally, there ought to be, the language in the constitution is there may be a select committee of about 11 members who will then go and interrogate these charges, return a report. And that could have been, for me, a more elegant way. And I'm juxtaposing that to the importance of this office of the presidency. Because remember, as we said earlier, this is a president in waiting. It's not just anybody. It's not just any politician. This is a person today, if the president collapses, actually will take over the reins of power and actually be the CEO of this country. So we ought to have attached, we're going back to the question of the spirit. What would have been the best way to go about this? Not to make the Senate a committee to impeach Gachagua. Because you needed to have attached importance. If you remove this person, what are the possible consequences? Because he's charged of being a tribalist. But today, I think the mountain is more united now, more than ever. The mountain is very much united, whatever you want to call it. But I think for me, wisdom ought to have reigned on the speaker, on the senators, to say, let's tread very carefully on this issue because of the implications. At least let's give an opportunity to a select committee to interrogate these charges, return to us their verdict.
You should have put that in the Constitution.
It is there. It is there.
Not as optional.
No. It is there.
You should have made it the requirement.
So maybe, Eric, I agree with most of what Dr. said in terms of either this particular trial or the challenges. But I think the question you asked is very critical. Look, ultimately, this is a political forum, and we had the choice to say in the Constitution, when we were making the Constitution, once there is an allegation for an impeachable offense, remove this and take it to an independent. Just like the section, the article before this one deals with a tribunal set up for incapacity. And the one before that deals with an election petition at the highest court in our country.
Yes.
In this particular instance, the Constitution has given this to the Parliament. So, for example, as I said, lawyers in this country naturally gravitate towards the courts and a court process. But ask yourself, if tomorrow Daktari or one of the lawyers in his office, now there's no impeachment process in the concerning, for example, a minister in the National Assembly or in the Senate, and then they decided this particular minister is not fit for office, I am going to impeach him, and they draft a very beautiful case and go before the High Court and say, Mr. Judge, I am moving your court because I want to impeach Minister Eric Latif, because he's unfit. And I have lined up all the witnesses, and I have lined up all the evidence, and assuming just in that case that we all look at the evidence and it's perfect,
right,
and we all get the best witnesses,
right,
would the court say, I agree with you and impeach? No.
No.
The court will say, my friend, this is not the home of impeachment. We have no powers to do impeachment here. Go to Parliament, where if you have other issues, let me just, if you have other issues, let's see, but impeachment, go to Parliament. The second is Parliament is a very powerful institution. Or the executive, for example. Supposing there is an election petition of a ward rep going on somewhere in a magistrate's court, and Parliament decides, we don't like the way that is being handled. We will handle it at supermajority levels in the House and the Senate. So we'll take part in that function. Most people would laugh Parliament out of. So the point I make is these are different systems. So most lawyers understand we have something called an adversarial system. Our criminal or civil law process in courts is adversarial. In other words, it relies on Daktari representing one person, I representing the other person, and you, Eric, being an arbiter who is not party to this process listening. And that we will be very adversarial against each other.
As opposed to?
As opposed to, say, inquisitorial, which is what either the French or the Islamic law has, which is that the court actually goes out of its way to look for the truth. In our system, our courts don't look for the truth. The judge could very well know that this is actually not right, but if you have not pleaded it, if the person who is starting this case has not said, I want ABCD, the judge can go out of this and grant you those things. So imagine now how that would look to somebody from the inquisitorial side. They'll say, how can that be? This is a court, it's supposed to give justice. And here you are saying the English setup is, no. You cannot go. And the lawyers in this country will be very comfortable in saying that you have not pleaded this, so we cannot answer that question. Or I am the judge, I can't ask this question. So this is now a different system, and it's a different forum. And unfortunately or fortunately, irrespective of how painful the current setup in our parliament is, or the current political temperatures are, and I agree with us, with many people who say our current parliament is the worst parliament probably we have ever had. Even the 1988 Mulolongo product. But the reality is our constitutional... Yes, sir.
Counsel, are the two of you suggesting that these processes that we have just witnessed were either a gross illegality or completely unconstitutional?
No, not really.
No. So the point I make is we might not be happy with our current parliament. Yes. But tomorrow, if that current parliament passes a law, we must abide by that law. And our current setup.
We can reject it if it's a bad law.
You absolutely can reject it if it's a bad law.
Just like we rejected the finance bill.
We can challenge it.
There you go. But the courts are given the power to strike down laws. The courts are not given powers to strike down impeachment, because impeachment is closed.
So what you're saying, the bottom line, hold on, Daktari, the bottom line of the Qadri, what you're saying is that the lesson from you in this class today is that we have two systems.
Yes.
We have a judicial way and we have a political way of removing a president in our constitution.
We have three systems.
We have three.
We have a medical way.
Okay, we have a God way.
Actually, we have five. Obviously, you can resign. You can die.
Yes.
You can be incapacitated medically.
Okay.
In which we have another procedure, not the courts, not parliament, but a process that is under the constitution. We have an election petition, which is a court process. And we have a political process called impeachment.
And the
now,
political
unfortunately, the lawyers and because of the unpopularity of our politics and our politicians, the push is to remove this impeachment process from parliament and give it to the courts. And I'm saying that's unconstitutional.
And you're saying
that's not acceptable.
This one is purely
political.
So then I will ask the question, and you'll start with that in the next hour after the news. So then why put such legal thresholds for political process.
Very good point.
CGO, constitution break, breach of constitution.
Very good point.
It should have been, we don't just like this guy. And you can marshal two-thirds.
Yeah, very good point. So Dr. will I'm sure have a lot to say about
let's
it.
do the news.
Okay.
You'll start on that. Okay. If really this is it's a purely political process,
yes,
then why have such high legal thresholds? Why not just say, if Parliament feels that this president or deputy president is so unpopular, and you can marshal a supermajority, just get the guy out of office, and you'll have the country behind you. 8 a.m.
That's exactly how